Hey everyone, it's Gary Rosner with the Broward Bar Buzz. Today I'm here with Gary Rosner and Leslie Berkoff from Moritt Hock Hamroff, the partner law firm of ours here at the Broward County Bar Association. Today we're going to discuss mediations and how attorneys can get prepared or prepare their clients, as well as mediators providing them some great tips. Welcome, folks.
Thank you so much for having us.
Wonderful.
Thank you, Braulio.
Thank you for coming. So Leslie, talk to us a little bit. Why is it important to prepare your clients?
So if you want to have a hope of a successful mediation, you have to put some work into it. A couple of different points. Not every client's ever been to a mediation before. They really should understand what the process is, what to expect, understand the mediator is not a judge. We're not making decisions as mediators. That they should reflect on and work with their attorney to understand their case. You've got to understand what key information is going to need to be provided to educate the mediator so that he or she can handle the matter, facilitate a conversation, potentially educate the other side to know about your claims or your defenses, depending on which side of the fence or the V you're sitting on. And spend some time considering what to really expect and what to ask for. Sometimes we talk about things like Watner or BATNA, best alternative to a negotiated settlement, or worst alternative to a negotiated settlement. Understanding your risks, understanding the rewards, understanding what mediation can do for you. Because in mediation, unlike litigation, you can be creative. The parties can be creative, the mediator can facilitate creativity. A judge is only going to decide something sort of, vertically under the law. This is what the law says, this is what I can get you, very black and white. In mediation, you can ask for ice in winter if you want it. You can ask for a new deal. You can ask for additional terms. You could bring in things that are maybe even outside the dispute. So spending time and thinking with your client, what do you really want to get? What is reasonable to get? And how to package that in a way that is effectively communicated both to the other side and to the mediator is really important. If you don't put work into this process, you are not going to have a successful process, and you should be entering it with the hope that something good comes out of it, even if it's narrowing of issues or better understanding the items in dispute.
In terms of preparing or attorneys preparing their clients, what have been the issues that you have found that have often destroyed the mediation or didn't let it be successful? Like that lawyer perhaps didn't prepare their client certain expectations.
So I think that the client has to understand you're not going in to argue a case the way you would in court. So even the demeanor of the attorney should really be different. This should be settlement focused. Clients should understand that even if they've asked for $1 million in their complaint or they think they're entitled to it, they're not walking away with that $1 million ask. Maybe if they litigate to the ends of the earth, they might get it. But in mediation, they need to understand that there needs to be a give and take. This is supposed to be a settlement. You've avoided the cost of litigation. I think when the attorneys do not get their client to understand that that's what this process is, and they all go in expecting to pound the table and just say, I'm right, I don't want to hear anything else, they miss something. Sometimes going in and not having had the client have the chance to think about the information that needs to be conveyed, the documents that need to be pulled, the right party at the table. You might be going in with Bob and Sally should have been there. You maybe should have been talking about the fact that they may have needed to do a tax analysis. So really failing to think about their issues and understand their case is one of the biggest impediments. Approaching it like a pure litigator is a big impediment. Sometimes I think not being willing to consider alternative solutions is an impediment. They get too lost in everything and not recognize what is going on. I've talked about sometimes the price of principle. It's wrong, I should just win because of X. That really isn't what this is about. And if you can't spend that time thinking about it, it is one of the reasons things fail, mediations fail, including, quite frankly, sometimes just not even understanding your case. I've had cases, because I serve a lot as the neutral, where the lawyer really doesn't understand the strengths and weaknesses of their case, and that may be okay, But part of what a mediator can do, a good mediator, is to help you evaluate your case. It's almost a form of early case evaluation or neutral evaluation in a different format. And being open to reflecting on that. So when you put up all those barriers and when you fail to do all of that, you're sort of setting it up to fail.
Right. I would think that your part of your job would be to kind of enlighten or shine a light on each party, their strengths and their weaknesses, because then for the lawyers, I would think it would be their job to talk to their clients about cost-benefit analysis in a way, if we're just looking at a business matter, right?
Right, absolutely. I think one of the other things that sometimes fails is, and mediation is unique, unlike arbitration or unlike a judge, I can speak to either party with counsel, I can speak to lawyers separately, I can have, effectively, there is no ex parte communication. So, sometimes I've had lawyers reach out and say, it isn't me, it's actually the client. Help me convince the client. Help me educate the client. Or me being open to a conversation where the client can be participatory. When you're in court, if you're in a litigation, the client gets to speak 2 different times. In a deposition, in a controlled response to designated questions. And we're always telling our clients, yes, no, or don't give up more than you need to, right?
Right, yes.
Okay. Or on the stand. In mediation, they get a chance to tell a story. They can do it in private caucus. They could maybe do it in an opening statement. So the client, if properly prepared, really gets to engage in a process, ask questions, and hopefully, if you do a joint session or through the mediator from caucus to caucus, you get to hear the other side's defenses, facts, story, whatever it is, but it's not through the lens of paper. And so what sometimes is really helpful, if you can get parties into a joint session or you can be a good mediator and convey the information, they're not just hearing the other side's responses through a set of pleadings, they're hearing it from a human being.
Sure.
They're hearing it couched differently, and sometimes that resonates differently. The other thing I will say sometimes is, and I don't always do joint sessions, sometimes they benefit, sometimes they don't, but I have been in mediations where the client is encouraged to speak. I always encourage them, and I always say, your attorney's in charge, but speak if you want to. I would encourage you to. And sometimes someone will say, privately or otherwise, I don't want that guy on the stand. He actually is really effective, or he really understands his facts. And then the flip side is sometimes true. If your client's a disaster, they should never speak anywhere outside a private caucus. So there's a lot that attorneys can think about and do, and knowing if your client is a strong witness, you may want an opening session that's joint. You may want the other side to say, hey, this is the person you're going to depose. This is who the judge is going to hear.
Yeah.
That actually has real value. You don't get that in a deposition. It's just not the same. You'll get some of it. This is a little different. It's more free-flowing. It's more open. It's less directive. And I think that recognizing those tools or strengths is really something an attorney can effectively use when they're preparing for something, to consider who should talk. Because again, you don't get to talk as a client otherwise.
So Gary, part of preparation is make sure you have all the information ahead of time. Why is it important for a mediator to have all those salient documents?
Okay, so I'll focus more on the attorney's preparation in regards to the mediator. Couple of items. Depending on the type of case, things that I can see that come up that will stall out mediations or may cause delays or cause an adjournment, which sometimes adjournments are necessary, but other times with momentum, parties don't want to stop. What can happen? Take a personal injury case. Before you come into the mediation, make sure to the best you can, liens, see if you can get liens negotiated. Are there going to be Medicare set-asides? Does the client know that this was, have a chart ready? I know when I'm sitting in the chair with a client and we're talking about a case, if it's a case involving a commercial dispute, one of the questions they may say, okay, I'm being offered XYZ. What have I paid your firm so far? What am I netting out of this? Have I recovered my fees? Or was this a case where the settlement really only did was cover my fees, the attorney's fees, and I didn't get anywhere with this? So I think as an attorney, you want to make sure you've got all your documentation to the other side. Under the rule amendments that took place as of January 1st, that's going to become less of an issue because of the mandatory disclosures. But you want the other side, especially if there's an insurance adjuster involved, homeowners claims, property damage, probate, breach of fiduciary duties, securities, any type of mediation where there are damages. Obviously, the abstract damages, the pain and suffering, okay? That's a little different. You can't really document that per se. But when you're talking about your hard numbers, have those documents, give it to the other side ahead of time and not the night before. Because if you're going to say in a construction defect case, you know, I have an engineer's report or I have an expert's report, and you throw this at the other side at 11 at night with mediation starting at 10 in the morning the next day, that's generally going to be problematic because no one is going to have prepared for this. You don't want to shock the other side and give them sticker shock, either party, when they think all along, well, there's $30,000, $40,000, let's say we're showing in lost income, 40, or if it's a business dispute, breach of a non-compete, okay, it's $200,000 we lost in business. And then all of a sudden your client calls you and says, it's not 200, it's 500. Well, now the attorney on the other side, he may be thinking this is a $200,000 case. In reality, now you've just sprung another $300,000. Speaking to the mediator, if you're not going to do a pre-mediation statement or report to the mediator, what a lot of people do, I do it myself when I'm sitting in the litigation chair. A lot of times I don't write a report. What I will do is I may send over pertinent documents, motion for summary judgment if one's pending, complaint, the answer, and then I'll write a summary up. And what I like to do is call the mediator, because there's a lot, you know, in this day and age, everything's email and text. You get a lot out of a conversation. A lot comes just from a conversation with the mediator. There's also the intangibles. If I'm mediating a probate case and it's sibling versus sibling or a parent versus a child, and it happens, it's part of the way probate works, let me know ahead of time, especially, you know, with the virtual, because 90% of the mediations are taking place virtually. I mean, I do them in person. I enjoy doing them in person. It just, in reality, you don't do a ton of them in person anymore. It just, that is sort of not the norm anymore. It's generally virtual. But that being said, if it's going to become the Hatfield and McCoys the minute we start, I need to know that, because there's certain things I'm required under the rules as a certified mediator that I need to express to the parties. They have to understand the confidentiality, that there are exceptions. They have to know that they have to make this decision under their own determination and volition. There's no duress. I'm not making rulings. If they look me up, everyone Googles everyone now. I'm a lawyer, but I can't give legal advice. As you know, in the state of Florida, you don't even need to be an attorney to be a certified mediator. There are mediators that are not lawyers. I can't give legal advice. They need to know that. So if there's going to be an issue, like I said, with two brothers or two sisters, or brother-sister family members, and if they're going to go at it, or two former business partners, you see that a lot of times in business disputes, especially if you're seeing breach of fiduciary duty, or they're alleging conversion that someone stole, or their embezzlement, they're going to go at it the minute you get in the room. Give me a heads up. One, I'm prepared for it. Two, the nice thing with Zoom is you can mute if you have to, everybody, okay? You can control that. But it may be, I'll say to the attorneys ahead of time, do you think I can even get your clients through the opening so I don't have to do it in each room? And I will say 99% of the time the attorneys will say, yes, I can get my client through that, but no opening statements. The other thing I would talk about is, and this is a big difference that I see, there's a mediator advocate and a litigation advocate. Mediation, by its definition in this state, if you look at the Florida statutes, it is a non-adversarial proceeding. And what I tell the parties when I start a mediation, you're here because of an adversarial proceeding by its very nature. Someone has a claim against someone. okay? But I say, at least for the time we're gonna spend together, view this as a non-adversarial collaborative effort to see if we can resolve the matter. And parties buy into that.
Hold on there, because I've been through this. So when you go in, even though you're told that, you still feel adversarial because you're thinking, this son of a gun, is coming at me, and it's malarkey, it's baloney. So how do you, as a seasoned mediator, how do you manage that? How do you control that? Because there's just that animosity there.
Okay,
Anyhow.
so there's icebreakers. First thing I'll do when I get on a mediation, has anyone here not been in a mediation before? And a lot of times, depending on the type of case, the answer will be yes, I haven't been in a mediation. One of the first things I say, because they're nervous. They're nervous. There's a bunch of people on a screen. Yeah, it's Hollywood Squares now, but they're still nervous. And I'll say, first thing is, everyone can take a deep breath, because nothing bad can happen here today. The worst case is we won't resolve the case today, and I'll talk to you all, if that should come to pass, I'll talk to you at the end of the mediation about what I will still endeavor to do to try to help the parties get to a resolution, even if on this day we weren't able to do it. Then what do I do? When I go into caucus, what I would do is, Braulio, if I see you're apprehensive, if I see you're that worked up, I'm going to start talking. Braulio, what do you do for a living? Make the person comfortable, because it does take them down. You'll start to see them relaxing by the body, because you have to know body language. If I see you sitting there like this in the opening, I'm already making a note to myself. Rosa is furious.
But much easier in person, obviously. I would think.
Yes. So what I will say to you is, and once you're in there, what I think is, and I never like it when it happens, and when someone says a good mediated settlement agreement, I'm sure you've heard it, is
No one's happy.
No one's happy. But here's the problem with that. That's not true. And the reason I know that is, I've asked my own clients after mediation, and they say to me, I may not be thrilled with the monetary aspect of it, but I said, well, is there anything that you're happy about? They said, well, one thing is, Gary, you're a nice guy, but I really don't like getting an invoice from you every month. Okay, so that stops. 2, I'm in the business of, I'm a financial advisor. I run a construction company. This is taking time. Everything that you're doing when you're on a deposition, I have to stop. And again, with the new rules, you got to move these cases.
Sure.
You call me up and say, Gary, I need all these things from you. I have to stop and get it. They'll say to me, I can now start working at making money and taking away that time from my business or whatever I'm doing. And there's a mental stress to it. It's not.
It is.
Lawyers,
It is.
I mean, the lawyers, we have a program in the state for people that are having, obviously you've seen the studies, it's not great in our profession, the amount, the alcoholism rate, the addiction rates. That's why the Florida Lawyers Assistance Program is, you always see it being advocated and shown all over.
It exists for a reason.
It exists for a reason. And so if lawyers who have been doing this, and they went to law school, they're out practicing, and they're doing this every day, are stressed, and they're having issues dealing with all the aggravation and stress that comes with being a lawyer, the party that is not, they didn't sign up for this, especially if you're a defendant, you didn't sign up to be sued. And a lot of times a plaintiff, it's not that it's not like they were looking and said one day, look, there are sport litigators out there, but the general person is not looking, I don't care what business they're in, they don't want to be suing. They would much rather be paying a lawyer to do transactional work, productive contracts, things that are going to be help.
It's a stressful thing.
It's a stressful thing.
No matter what.
And I think that's why it's important. There are non-monetary aspects, so I don't agree with that statement, everyone leaves unhappy, and I never use that statement. In fact, I tell the parties up front that I don't like the statement, okay? And parties understand that, and I see it. And as from a mediator standpoint, I may see you gritting your teeth like this the whole time. And I may say, Braulio, you know, as I'm comfortable and there's a rapport built up, I'll say, Braulio, is this worth it? Because you look real stressed to me. Is there a point? And you have to be careful. Look, you have counsel, you have to do it, and there's a way to do it. And every mediator has their own style, but you have to read what's going on. And the attorneys, the last thing I'll say with the attorneys is mediator advocate versus litigation advocate. Mm-hmm. If you're going to come into the mediation, okay, and everyone wants to litigate zealously for their clients, some cases have more emotion involved than others. But if especially a probate, certain types, if it's two siblings fighting over a business, there's going to be more emotion. If one attorney comes in there and is basically, I'm going to put you on the stand and this is what's going to happen when we go to court and this is what I'm going to do. Okay, it's everything that you're doing, the attorney on the other side probably has already prepared their attorney for that type of situation, but what you're actually doing is you're taking someone like me and Leslie, and now what's going to happen is, and I've had it happen where I've said, this is not a great idea, and so, you know, obviously if it gets out of the realm of professionalism, you stop it. There's certain rules, but sometimes it goes a little, you know, it's just too aggressive. And what happens is I have to go in the other room and they'll say, it took you an hour before you even got back to us. I said, yeah, it took me an hour because it just took me 40 minutes to get that party to stay and not leave.
Lock them off the
because
ledge.
they're ready to leave.
Yeah.
So just be mindful. Mediation advocacy doesn't mean you're laying down. You're still putting your best foot forward. But you have to, if you're there truly to try to resolve a case, you have to do it in a manner where you're advocating for your client, you're educating the other side about things maybe they don't know or you're not sure getting back to the client, but you're doing it in a way that you're not getting the other side where I can see, you know, the redness is going here, to here, to here, and by the time they're done, they're cooked already. They can't even think about a logical resolution.
So Leslie, Gary spoke about he touched a little bit on no surprises. Is there anything that you would want to add on that?
So I think it's really important. Sometimes, by the way, you know, some of this is early stage mediation, things are coming out. And depending on how it's set up, whether people are doing a submission, a joint submission, or just giving information, you know, I talk to people about the following. You know, when you talk to your client to counsel, there's privilege. When you talk to the other side, obviously everything's sort of withheld and veiled. And I try and convince people that as a mediator, I know people don't want to actually tell us everything. I don't necessarily want your bottom line. I mean, I wouldn't mind it, but it'd be helpful. But I get that. But there's a football field in between. So the point is that sometimes what I need to know is these two parties can't be in the room together, whether it's a Zoom room or in-person room. You know, this is not an avenue. There's a reason that they're asking for X, and X will never work in this business because of Y. Because when I start into a mediation ahead of time, if I have the opportunity to get a submission, if I have the opportunity to reflect on it and speak to counsel, and some of the cases I do, there were really opportunities to do that, I'll talk to people ahead of time. I start thinking about a path to success, a resolution. I start thinking about how I want to approach it. I may be going trajectory left. And if that left is a dead end because guess what, that just can't happen and no one has shared that with me, I've got to pivot. And I'll pivot, but you do better sharing more with me. And I really encourage them to do that. I say to them, whatever you tell me is staying in the room. Okay, I will ensure your confidentiality. I take tons of notes. Tell them the notes all get shredded. I do too many mediations. You can't subpoena me. I'm immune. If you did, I wouldn't remember it anyway. Doesn't matter. But the more, it's impossible. But the more you educate me, I am a tool in a toolkit. That is what I am. You want me knowing as much as possible because what you want me to do, both sides, you want me to be your advocate in the other room to get you a deal. And I don't mean a biased advocate. I mean you want me informed so I understand what you need, what you want, so I can try and maneuver the parties to a result that makes sense for them and that they can live with. If you withhold information, and I've had cases where there was one where I don't remember why, it doesn't matter for this purpose, they we were like 7 hours in, and they're like, well, we have this document. And I literally looked at them and I'm thinking, you know, if I'd only known about this 7 hours ago, and what I always tell the parties, a couple of things. I never waste anyone's time. I have a very high success rate. I'm very good at what I do. I will not waste your time. I don't need to keep people around. You're lovely people, or maybe you're not. I won't say that, but I will. But trust me, if I think we're getting nowhere, I'll call the mediation. Trust me.
Yeah.
But if I've asked you to stay, you've picked me as your mediator because theoretically you trust me, or someone has told you to trust me. If you don't see something happening, you don't know what's going on in the other room. I am the only person that knows what is going on in both rooms. If I ask you to stay, I may see a path that you don't see. They may not be ready there. I may not be able to bring you that information. But the more you share with me, so in that instance, the document that they had was an issue that they couldn't figure out. I wasn't yet able to share it or identify it. And I'm sitting there going, we could have settled this thing 6 hours ago.
Yeah, why'd you do this?
I had just had this document. And the other side was asking this question, and I was, again, you can't share with the other side. And so I will say to people, very forthcoming, I encourage you to be as fulsome and upfront as possible with me, because you don't know what it is I'm hearing in the other room. You don't know the questions. I'll never divulge something you'll tell me I can't say. But if I know it exists, and I know what they're asking, I can find a way to maneuver the process so that either you're ready to release it, they're ready to hear it, or I've opened the door to it. And so holding back for me makes no sense other than, and I respect this, if they tell me they're gonna settle for $100,000, they don't want me kind of just jumping to that, which I would never do. But having a range, having an understanding, getting a sense of things, and besides, when people tell me what they will do, I never believe them. I know money's always being held back. It's just
the game.
It's the game. The interesting thing is I do mediate with a lot of the same people, lawyers more so than anything else, and a lot of them I do reach a point where they know that if they share enough with me, I'm not going to just throw that number out, but they know that it lets me get to, I hate to use the expression get to yes, I really don't love that book, but it lets me get to a result sooner, because now I'm like, okay, I know where your range is. Let me figure out how to encourage them to do that, or to consider whether or not a mediator's proposal is appropriate, which I use cautiously in the right circumstances. And if you do not know how to use it, you should not use it. It is a very skilled thing to utilize that as a tool. You know, I've talked about this, but you can misuse it. It can backfire. But if used right, in the right circumstances with trust, it can be a tremendously great way to settle a case.
So Leslie, is there any real high-level items that you want people to reflect on or take away and be prepared for?
You know, I want to pick up on just something Gary said, because I echo it. So sometimes, you know, when I'm getting people to resolve, you get to the point, you know, they've gotten to their number, and then they throw out this number. It's going to cost me X dollars to try this case, or X dollars to
Yeah, that's what
make
you
a
were trying to
motion.
figure out,
Right,
cost benefit.
right, and they'll do that, which, by the way, I would love any lawyer and any client to ever actually live up to whatever number gets thrown out, because it's never a real number. It's $10,000 to try this case. Really? You're going to put that in writing?
That's
Come
baloney.
on, it's baloney. But let's say we get past that. So they've said my risk is 80%. It's going to cost me blank. Here is my number. And picking up on something Gary raised before, which is a very good point about the stress level, I have a term for it. It's called the lost opportunity cost, which is while you are sitting here, while you are being deposed, while your client and your employees are all pulling records and sitting in the other side's depot or sitting in court at a trial, you're not running your business. That has a value. You valued your percentage risk of winning or losing the case. You valued the cost of litigation. And I have to be within a realm. And there's no set realm. It's a gut feeling of where we've gotten. You know, you get them close enough. I said, you can't tell me it's not worth 15, 20, whatever the number might be, to be done with this. Because you're not making money.
Right.
And your employees aren't making
You're
you
spending,
money.
you're not earning.
You're spending, you're not earning. And the breath of fresh air, the not, you know, when we talk about everybody being unhappy, I agree with what Gary said, is, no, nobody's happy that they either had to pay money or didn't get everything they thought, but the relief of being done and being able to focus on whatever business it is that you do is so usually worth it. You've reached the right settlement where they can live with what they're paying and they know they can move on. And that's where that saying of, everybody's unhappy. No, you may be unhappy because you didn't get everything you wanted, but you're never getting everything you wanted unless you win this case, slam dunk, hands down, and how many legal fees later and how many years later. The answer is you can move on with your life because this is what we do for a living. This is not what they do for a living.
Yeah, touche. So I've learned a lot today, and I think there's been some great insight and great tips for people, lawyers, mediators, and even the public. Any final thoughts?
I would look at mediation. It's a golden opportunity. I speak to lawyers in other states. Our mandatory mediation in the state courts here, you don't find that in every jurisdiction. It's a golden opportunity, and that's how attorneys should look at it with their clients. Because sometimes clients, especially clients that may be litigating out of state, they may come in and say, "It's my first, I've gone to mediations in some jurisdictions where the success rate isn't there, and it's not it has nothing to do with the quality of the mediator, of who's ever acting as the neutral. But Florida has a high rate of success with mediation. It has a high rate, and attorneys and clients, especially if you have a client from out of state who's the first time mediating here, let them know that in Florida, it's mandatory, it's mandated, it's in every trial order. You can move to dispense with it. You rarely see that granted, because how many times have people gone and said to the judge, we shouldn't go to, you don't see it that often. People just don't file them anymore. But if they file, I've seen it where they argue and say, "Judge, there's no chance we're settling, so there's no reason to go to mediation." And I've spoken to judges, and they say if they had, a dime for every time someone had said that when they file those motions, which I said rarely get filed, and from what I see, rarely get granted, it just doesn't work. Look at it as a golden opportunity.
Gary, Leslie, thank you for stopping by. I appreciate
Thank
it.
you.
I hope you guys come back again soon.
Thank you
pleasure.
very
Thank you
much.
so much.
Pleasure being with you.